Well, good morning. I'm RJ Kelly, founder and chief visionary officer of the Wealth Legacy family of companies and Wealth Legacy Group. We're here in San Diego, although we've got clients in 19 states, I'm told, and counting from there. It's one of the great things about, I don't mean to make light of it, but it is one of the great things about what's happening with the coronavirus. It is for those individuals that have not been using Zoom. I'm always surprised by how many people have never used it, or in this case, Ring Central. But we've ended up finding more opportunities for clients now across the country. And I know it's probably you're finding that as well. So there are blessings that have faced us in this challenge in the last 7 months. And so grateful for you and excited that you're with us today. We've got a good number of folks that have signed up, and that given the narrowness of the topic, that's encouraging. So we know that you want to find out more about buy-sell agreements. So let's quick, we'll talk about a commercial, as for some reason that slide is not wanting to advance. There we go. So let me just run by what we're going to be hitting today. Why a buy-sell agreement, why it's a good idea, and frankly, even more than that, why it's essential for every business owner. The first day you open the business, terrific. Day two, you need to have a succession plan in place. What happens when you retire 20, 30, 40 years from now? What if you get hit by a Mack truck tomorrow, God forbid, or have a stroke? Any number of different things, 17, 18 different items. We're going to go through a number of those today that you need to make sure you've got in that buy-sell agreement. So it is critically important. We talked about highlights in terms of, what do you value and when do you value that? We're going to talk about a case example where they did not have a buy-sell agreement and what happened there. What are some of the key considerations that you need to have in your agreement? And we're just going to do a glancing blow on valuations. I want to give a shout out to another good friend, Cheryl Kessler. If you go to wealthlegacygroup.com, our website, you'll see in a minute. But if you don't go there now, please. But if you go to wealthlegacygroup.com, click on our video section and scroll down just a page, you'll find Cheryl's presentation on valuation. She's one of the top valuation experts in the country. So we're not going to do a deep dive into that. I will do a glancing blow. And it is critically important that you have a valuation done for your business that's contemporary, that's available. That's very important. Troy's going to talk about some of the things that are preventable and what's getting people in trouble. How do they end up in court? And you don't want to be one of those people that gets famous that way. How do you fund it? And then what are some key things for the business succession planning itself? I mentioned a moment ago, we have clients in over 19 states. I've been in practice now well over 30 years. I love what I get to do. I'm truly the most fortunate guy in the whole planet because I adore what I get to do. We have amazing clients. A number of you that I see already have logged in. I have an amazing, wonderful staff headed by my wife, Demian, but I'm grateful for the team that I get to work with. We do a variety of different things. Yes, we have an investment management group. I'm an independent registered investment advisor. I'm happy to report that as of yesterday, my own personal account was up 13.69% so far this year, net of fees, other than an advisor fee. And over the last 12 months, the trailing return is 16.45%. So it's a great idea for you to ask your investment advisors how they're doing in their own account before you let them touch your money. So there you go. But truly the why behind what I do in my professional practice is my father died when I was 18. And I saw what happened when a multi-million-dollar company, when the visionary died, and within 10 years after my father's death, the business was bankrupt. Now, fortunately, because we worked with a very wise attorney, such as like a Troy Romero, but my father and mother had put some asset protection strategies in place, so we didn't lose everything, but we lost the business. And as devastating as that was financially, it was just as emotionally devastating to have men and women, mostly men, given our industry, that had been with us, some of them 20 years, 25 years. And for some, Kelly Oil Company was the only business they'd ever worked for, and they lost their jobs. And that was also devastating. And I just made an emotional commitment that I was going to never let that happen while I was on watch. So that's the biggest why behind what I do in my profession in terms of our practice. So I want to also introduce a wonderful friend. I've been a raving fan of this guy for years now. He has a practice both in Washington State, as well as a thriving practice, a long-time practice here in San Diego. He is in the practice of Romero Park. They focus on helping business owners with the development, strategic planning, the expansion, and the resolution of when conflict happens. I mean, the fact is, you get two people, there's going to be conflict. And so sometimes that spills over into very unpleasant situations. And Troy has personally overseen over 500 business divorces, as he calls them. On Monday, when we did a walkthrough, he had been in 3 different litigation matters that day alone. But true to his character, he was still upbeat, he was still positive, he was still just the caring, wonderful man that he is, that I've come to really appreciate. And I don't know how he has time for this, but he's also the co-owner and chief enthusiasm officer for Spire. That's how I first met Troy, was through Spire. I see a number of Spire folks on today as well. And Spire is this remarkable organization that is driven to bring people together, professionals and business people together, to help them increase their capabilities of their craft, but at the same time to imbue in them more purpose-driven direction, and then to network those purpose-driven professionals and business owners together to really have a lasting positive impact in our San Diego world. Recognized as one of the top 40 under 40 in Washington State a few years ago, and his boyish good looks, you could think that happened yesterday, but it has been a couple years ago. But he, in the last 6 years, has been recognized as one of the top attorneys in San Diego for his craft. So Troy, it's just a delight to be with you. Deeply honored that you would join me on this venture today. And I also want to make one more point, is that for those of you, especially that are business owners out there, if you want to sit down and have a 30-minute complimentary conversation about your buy-sell agreement, or what's in it, maybe what's missing from it, or what would it take to get one in place, I've arranged with Troy that we will sit down and have a 30-minute complimentary conversation, as I've said. So just let us know. We're going to be sending out a survey afterwards to get your feedback on how we did, how we can do better, and what you want to hear from another time. At the same time, if you want that 30-minute conversation about your buy-sell agreement, just let us know, and we will, Damien will reach out and schedule that. Okay, so let's get into the meat here. Your buy-sell agreement. Do you have one? Let's start with that one. And advisors out there, and I know we've got a few that are in with us today. Do you routinely, is it part of your practice to ask them about it? This is a growing litigation area for all advisors, not just attorneys, but CPAs, financial advisors, and consultants like myself, and others that are on the call today. I've seen banks are being challenged in this area. So do you have a process for asking? Owners, do you even know what your buy-sell agreement says? Again, assuming you've got one. Has your business situation changed? The answer is usually yes. I had a buy-sell agreement where I asked him, do you have one? He said, yes, and thought that was the end of the conversation. I said, well, have you had any life changes? Have you gone through a divorce? Have one of your partners, have you added partners? And there's this long pause on the phone. Well, he had been divorced over 4 years ago, remarried. His documents were well out of date in terms of what needed to be addressed. So stuff happens. Is there anything missing in the document? There are a number of key factors. Troy's going to hit some of the big 5, but there's a whole bunch more. And then last, as I pointed out at the beginning, has the business been valued? And if so, by whom and when? Now, every closely held business needs a buy-sell agreement, especially if there's multiple owners. But I'm going to suggest to you that even if you're a solopreneur, you need to have a buy-sell agreement. You should consider one, maybe with a strategic competitor or friendly competitor. Again, a big part of it is deciding what is your exit plan going to look like. How will you leave it at some point, or do you want to pass this business on to into executives that may be on your team? Is it going to be a management internal buyout? Will it be family members? And if so, should they be trained along the way? Just because their last name is the same as yours, it doesn't give them the abilities to run your company. So even if you are a solopreneur, as I've said, you should consider a buy-sell agreement. And then what are the triggering events? Troy's going to talk about that more in a minute. And a big one is it going to be mandatory or voluntary? That is, do you require a buyout? And if so, at what price? And how's that valuation determined? Or is there another approach to it, what I call a Hewlett-Packard buy-sell, for example? And then what if the primary buyer simply can't execute the buy-sell and the funding and the agreement at the time of when it's supposed to happen? What do you do then? Well, you better have a backup buyer, whether that's the business or, again, something else if the original buyer, if something goes south. Talked about it a moment ago. What's the valuation process? What's the methodology? Maybe you value that business now, but the buyout doesn't occur for a number of years. Well, what's the methodology for valuing at that point? God forbid, if a death occurs, you want to make sure that the value of that business is established as the date of death, not after life insurance proceeds come in or other things where all of a sudden it artificially inflates the value of the business. And yet I've seen too many agreements that's exactly what would have happened if someone had died or become disabled. The valuation would have been increased because of the money coming in. So again, that's the point of how and when will that value be determined. Now, let me share with you a very sad story, frankly, about parents, good-natured, good, well-intended parents. They set up an LLC to hold some apartments, great asset, particularly here in California, or with my friends Kevin and Jeff, with what they're doing with Meridian, individual homes back in Memphis. Very clever idea. We'll talk about that another time. But how do, in this case, this family set up an LLC around an apartment building? They did the things they should do. They got a valuation, and then they use adjustment, or what I call compression strategies, where a dollar is no longer valued at $1. It might be valued at 70 cents. And so then they gifted this discounted value to their 3 children. And only one of them was actively involved in running that apartment complex and building. The other 2 were passive owners. And so when the second parent died, and that's usually when the guardrails come off the bridge, is when the parents die. So when the second parent died, the guardrails came off, and the manager, who was the son, said, you know what? I want to buy you both out, to his sisters. And I'm the only one that's doing work. You guys are just getting benefits, and yet I do the work. That's not fair. So he offered to buy them out, not at a fair market value price, but at the discounted value that the parents had used when they made the transfer, which is, of course, an artificially low number. There was no buy-sell agreement in place. So therefore, they did not come, let's just say, that did not end up pretty in terms of the introducing warfare that broke out between the brothers and the sisters. There was major litigation, and unfortunately, that family was destroyed. So that's just one small example, and unfortunately, both Troy and I can give you example after example of other situations where there was no buy-sell agreement, or it was out of date and didn't address certain things that might have happened. So, see, Troy, I've lost my number here, so I think I'm getting close in terms of when I pivot over to you. So just a couple of the things that mechanics for resolving disputes. What happens if in fact it does go to a dispute? How do you disagree agreeably? And again, oftentimes it happens after the children die. What do you do in terms of if a member of that owns stock, in terms of being able to sell to an outside party? That's what we call the rights of first refusal, where the current owners have the rights to buy out that stock or the ownership interest, but at the value that an outside buyer might have. So first rights go to the other partners. Does your agreement have that? What about minority partners? Do they get veto rights, or is it only for majority owners? Do minority partners get a seat on the board? But again, those are some of the issues that need to be addressed. So Troy, let's go over to you and talk about some of the common triggering events.
All right. Well, good morning, everybody. Thank you for showing up. We appreciate that on a certain morning. I am going to take over now and maybe drill down with a little more particularity on some of the main things, main provisions, and frankly, what become the main challenges in disputes and on buy-sell agreements. So when you are trying to decide when a buy-sell agreement gets triggered, there are lots of different things that you can make as triggering events. I've seen agreements and drafted agreements that have 10 or 15 of them. I've seen some that only have a couple, but we wanted to go through the 5 Ds, the 5 that are probably the most predominant and the ones that you can check against your own. So first off, obviously, is death. I do have some clients that say they don't want death to be a trigger. They want their spouse to be able to stay on. but most people want to have death be a trigger because they're in partnership with, the people they are, not the spouses of the people they are. And so that tends to be a pretty common one. The second one is disability. And that one, that there's a lot of drafting that can go into that in terms of incapacity. Is it they can't come to work for 6 months? Is it a medical professional? Can you do it and force them to be determined to be incapacitated? There's other nuances to that, but not having a permanent disability as a trigger is a bad idea, because otherwise, you're litigating with a partner potentially who's disabled, and that's just not a good, healthy thing. So you should have that be a trigger. The third one is divorce. Highly, highly, highly recommended. If you have a buy-sell that doesn't have it, you're in for a bad idea, a bad potential situation, because in a community property state, you're going to live with that idea. And so it's really important that a divorce will trigger it. Now, most people will have that trigger be that the spouse that's, the partner, shareholder, member, depending on our vernacular, gets to buy out their spouse as opposed to the other partners. But if they can't, then the other partners will be able to step in. And let me put an asterisk right there. When I use the word partner, shareholder, or member, we're referring basically to the same thing, right? Which is an equity holder. Obviously, an LLC, the nomenclature is a member, and if a corporation, it's a shareholder, and technically neither are partners. But my experience, I've been doing this for 31 and a half years now. My experience is most people refer to their fellow equity owners as partners. And so I've become accustomed to that. But don't be mistaken. We're not talking legally a partner. You're either a shareholder or a member, okay? But I'm going to use all three interchangeably for purposes of this discussion. The fourth D is disagreement. That's really important, and most buy-sell agreements are going to have a provision that talks about majority, supermajority, unanimous, and those kinds of things, and you should discuss those, because there could be some pretty serious disagreements on that, especially if you're on the minority position as opposed to majority. And then deadlock, my very favorite. If I had to take my 500 plus business divorces, I think it would be fair to say that almost half of them are, maybe even more than half, are 50-50s. For whatever reason, so many people get into business with one other person, whether it's a family member, a friend, somebody they were in business with before, and with all the knowledge that they have that they should have an agreement in place, a buy-sell, they don't, because they're buddies, they're friends, they're family members. And unfortunately, if you do not have that and you become deadlocked, you are going to be in a world of hurt in all likelihood. So those are the 5 things you want to make sure are triggering events. Additional triggering events, if your fellow equity holder is an employee, you will want to have it be termination. And then the debate will be, is it for cause or not for cause? This can be a pretty challenging thing, because when it's a 1 or 2% employee, maybe you have a ESOP, or maybe you're doing some stock options or something like that, and you have a little 1% or 2%, that's not a problem. But what if you're the 55% owner or the 80% owner? Are you going to agree that that you are forced if you decide to be quit or whatever it might be? Now, the good part is you should be able to control your employment, but that needs to be looked at from both sides, your side as well as everybody else's. Another thing is long-term illness. There are some insurance things that RJ will talk about that can kind of cover that loss, but that is another one that often should be a trigger. Reaching normal retirement age. I have a group of 6 CPAs up in the Sacramento, well, I shouldn't have said that. I have a group of clients somewhere in this world, and this became an incredibly difficult issue because they had differences of opinion as to what should be retirement age. So don't ever say when you retire, because somebody might say that's 50 and some might say that's 75. Pick a calendar age, but it's a good trigger to have. The early out, that's a discussion it's probably used less often, but it's a great one to potentially put in as a trigger. What if I just want to call it a day at 45, or I've hit $2 million and or whatever it might be, and you decide you want out. And then going to work for a competitor, obviously this should be an absolute positive. If anybody ever goes to work for a competitor, it should be an automatic trigger. And loss of professional license, if the entity obviously is medical, dental, legal, CPA, wealth management, anybody that loses a professional license, it's got to be a trigger, because in fact the law may even require that. Some other consideration. Oh, hold on, that's you. Right?
You're doing great. Why don't you just keep going on it, because it ties in so much to what you're talking about.
Okay. Sorry, I get all jazzed up and then I forget what in the world I'm doing. All right. So some other considerations that you want to focus on is what happens if a shareholder personally guarantees a loan and the business defaults. So you might say, well, why in the world do I even care about that? But unfortunately, most businesses, especially startups and emerging businesses, have a PG on. And, you know, what if that person goes out? You can't force the lender to let you out. So how are you going to handle that? Is there going to be indemnification or not? Are they only allowed to be bought out if they get out of their PG, etc.? Obviously, you'll have a huge difference of opinion whether you're staying in or you're the person going out. If you're going out, you want the PG gone. If you're staying in, you want to do your best to help them. But if not, you don't want to disrupt it. But it's something that should absolutely be addressed in your buy-sell agreement if you have one, because you can't control what the lender or the third party is going to do with that PG, even if they're gone. Next one is who handles the purchase or voting of a shareholder stock if they're deceased or disabled. Powers of attorney, we're going to spend a little time on that, but that's an important consideration, because what if they just happen to be incapacitated for a couple of days? You know, they had a car accident or something. Do you have in place a decision on what will happen? You do not want to have to try to find your partner got into a car accident. They'll be okay, but they're out in the, you know, for the next week or two, and you have to do something now. You need to have in place what the backup is. I'm going to turn, RJ, why don't you do the Hewlett Packard precedent?
This was something that was shared with me many, many years ago. I wish I could remember who to give credit to it. But the point of it is that in terms of the question of a mandatory versus optional buyout of a disabled a partner who's died, so forth. And there are some organizations, some companies that have become set, there's so much synergy, so much impact that they're having. They've got enough other support team and management team in place that requiring a buyout could be really very disadvantageous to the first partner to die, or better put, to their family. That is, you know, if you think of Hewlett Packard, and what if Dave Packard, let's just pretend, had died early on in the formation of Hewlett Packard? Well, the Hewlett family would have received billions of dollars of value over the years, even though Dave Packard was very involved early on and for many, many years in creating that organization. So the point is that if there is a situation where a business could continue on after the death of, say, one or maybe even several of the partners, if it's grown that big, rather than having a mandatory buyout, why not let the ownership interest stay with the family? But it's absolutely imperative then that you give all voting control to the surviving partners so that their hands are not tied, because typically there's a difference of opinion. The family of the deceased partner or disabled partner, their interests are really about getting income. Whereas the business owners and partners that are left, their focus is on continuing to grow the business. So those are typically at odds with one another. So with that, if you're going to use a Hewlett Packard type of buy-sell agreement that does not require a buyout, the thing to do is to make sure that there's plenty of life insurance for those family members so that they have the replacement income from those sorts of assets, the insurance, but give the voting control to the surviving partners. Hence, that's the Hewlett Packard buy-sell agreement. And there's also times where you might have a buy-sell agreement where there's multiple partners. I've had companies where we've had 8 or 10 partners. And if you try to have an agreement that says, okay, one partner dies, all 9 of us buy out their remaining shares, that's what's called a cross-purchase agreement, that gets to be really messy. However, if you have a trustee that is involved in the middle to buy the shares from that deceased partner or disabled partner, you could still have certain tax benefits in doing so that inure to a cross-purchase agreement. as opposed to having the business buy back the stock or the ownership interest. That's getting a little deep, so I'm going to just leave it there and park it there and give it back to my friend from Romero Park. But Troy, those are the 2 points. Thanks for letting me to at least tie in on a couple of things. How about though when you've got an S corp and you've got an owner where there might be a disagreement between partners, and and there's a taxable distributions but no money released to pay taxes? How do we handle that?
Yeah, and that's a great point. And you know, this issue is usually not addressed, unfortunately, in buy-sell agreements. And so it becomes a battle of, we'll call it past performance. If the LLC or the S Corp has covered all the partners' taxes for say 5 years, 10 years, 15 years, and then all of a sudden there's a buy-sell trigger and you buy out your 25% partner or whatever, they're going to expect a tax distribution to cover or a distribution to cover the taxes. And you're going to say, no, you don't own it anymore. And there's always going to be that 1 year lag time. And so that often will become a battle, and especially depending on how much money that is involved, it could become a litigation matter because, you know, a partner, everybody's expecting that the company is historically going to do that. But, you know, on the other hand, everybody expects you to be a shareholder or a member at the end of the year. And if you're not, why should the company cover you? So you should handle it one way or the other, but address it now, because otherwise it will be a source of contention, no doubt. So the other thing that I wanted to cover, you know, RJ and I went through this. We could have spent 4 or 5 or 6 hours on this topic, but we decided we're going to do it in an hour, and we're just going to hit the very, very most important things. So to me, a trigger is probably the most important. This would be the second most important in my hierarchy of importance in buy-sell provisions, and that's how in the world are you going to value this thing? And there are 3 main ways to do it. Everybody loves to use fair market value, right? But if you don't define it in your buy-sell agreement, guess what? Reasonable people can disagree on what fair market value is. I think it would be fair to say that the case law would say that fair market value presupposes that discounts are applied. And you see, I just noted a couple of them. But if I have a 5%, let's say my company is worth $1 million, so we have easy math, right? And I own 10%, the presumption would be I have $100,000 that you have to pay me to buy out my 10%. But the reality is no human being would ever pay $100,000 for 10% of a company. They just wouldn't do it. There would be a minority discount applied. There would be a lack of market, applied. And there are other discounts the business valuation people will apply. And a minority discount alone can run, you know, on the low end, maybe 10% to a high end of 50%. Well, if you have just say that we'll value based on FMV, guess what? You are going to potentially have a problem. So you may decide to do this, number 2, which is fair value, okay? Now that suggests then that we aren't going to apply those kinds of discounts. But then if you use the word fair value, guess what? Fair to whom? Fair to the 1% owner, fair to the majority owner. So again, you know, my recommendation is actually not to use either one of those terms, fair market value or fair value by itself. My recommendation is to use the term you want and to explain what you think it means. Now, for those of you who are either in a husband-wife, or a spouse relationship or a significant other relationship or something like that, investment value is one that you will see a lot. I personally I've never done an actual family divorce, but I have, but I have done maybe 40 or 50 business divorces where I'm brought in because the husband and wife own the company. And of course, they never had a buy-sell agreement ever. In fact, I don't want to say never, that would probably be too much, but it would be a very small percentage because they're husband and wife or, you know, whatever, and they feel like, why do I need one, right? But investment value is one that the courts in the family law genre will apply. And if you want to do that, you can put that into a buy-sell agreement. So those are kind of the three main ways to do it. But guess what? If most, like I said, the more precision that you have in your valuation methodology, the less likely you are to have disputes. And as RJ said, in my background, I'm a hybrid. I'm both a trial lawyer and I'm a business lawyer, and I do both. And I like that because when I'm drafting agreements, I'm thinking about trying to keep my clients out of litigation. And when I'm in litigation, I'm trying to think, how do I get them out of litigation and find a business solution? So what I thought I would do is give what I consider to be the 6 best ways to actually put the language in your buy-sell agreement on how you would want to value. The first one is the valuation by principles. I have, we probably manage, we're probably a registered agent for maybe 300 companies throughout the United States. And I would say of those 300, maybe 100 have a buy-sell. No, maybe 150. And of those, I would say 10% go with this. So it's not a real popular one because it's popular in the sense that it's really easy, right? Once a year, you just say, hey, what's our value? Okay, it's 5 million, great, and that's it. Of course, the con is most people forget to have their meetings. They don't ever update it. It's likely inaccurate. Guess what happens? If the last time you valued your company was, in 2009 and you die in 2021, I guarantee, well, I shouldn't say guarantee, it's highly likely your spouse or your kids or whatever are not going to go for that, or your partner's kids. They're going to argue that this was just an inadvertent mistake and it needs to be brought up to speed, and guess what? Now you're in litigation. The second one is an easy one. It's book value. Your accountant, your bookkeeper, even you probably, if you've got some financial acumen, can figure that one out because it's just assets less liabilities on the balance sheet, right? It's really, really simple and almost impossible to challenge. But of course, the con is if you're the one selling, you are not getting anywhere near your value, especially because it doesn't take into account goodwill, which is really the core of almost every family-owned entrepreneurial venture, is this idea of our goodwill and what we've got going. So great if you want to buy, terrible if you want to sell. All right, number 3 is fair market value determined by appraisers. And RJ said he's got a great business valuator he works with. I work with some as well. I'm not going to spend time on it because I am not a business valuator. Here's what I just want to kind of point out on that is you could, I have seen buy sells that have between 2 to 3 pages of information about who the valuator is, what their credentials are, what their licenses are. You can go full, or you can just say, hey, we'll pick an appraiser. I will tell you though, when you decide I'll just pick an appraiser, guess what? You potentially could litigate over what that means because, is it a good person, a bad person? Are they your buddy or your friend? Blah, 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 blah. But what's great about it is if you do pick an appraiser, anybody's ability to challenge it, assuming they're competent, is almost zero because presumably they're an expert and it can't be challenged. Con, of course, you got to get somebody. It takes a lot of time, and oftentimes you'll see in buy sells where they'll go, if we can't agree on one, then we each pick one, and then those two pick a third, and then you got this humongous cost, a lot of time, but it will definitively decide it for you. So some people think that's the best way to go. Fair market value determined by company CPA. I literally just settled a $8 million dispute 2 weeks ago in mediation on this very point. Pro, guess what? Your CPA knows you well. Every year they probably give you a valuation. If not, I'd encourage you to consider that. They definitely would be less costly than the appraiser because they've been working with all the books. The con, and the reason that my client got into litigation, I represented the company against the 25% minority who decided to resign and was able to put the stock to my client, is that the CPA had been the CEO's buddy for about 30 years and did his personal taxes, and so they argued he was biased. And I think it's terrible, but guess what? It was enough to get a dispute and produce litigation. So be careful on that one. Number 5 is you can set your value per share or unit. One of the things you'll see, and RJ will cover insurance in a while, that can be actually a pretty cool way to handle it. by just saying, look, this is the way we're going to value it. And, and the other reason that this could be nice is that there's no dispute. What happens sometimes is, what if you dilute? What if you redeem? What if you bring in an investor? Lots of times on these buy sales, you don't think of coordinating that situation. But if you pick a value per share or per unit, it doesn't matter what happens. You've agreed to it. But obviously, it's a terrible way if you're the person selling out, because it doesn't account for growth. It doesn't account for decrease in value. And so it's a really risky proposition. I wouldn't use it, but some people love to do it that way. The sixth one of actually my favorites, if the company can afford it, and the individuals, is Key Man Life Insurance, because it sets it, especially good for family members. I have a client in San Diego, 2 owners, 2 brothers, and they just agreed that the value of their company is $10 million. They don't care what it's going to be, whether it's high or low. I guarantee you it's not worth $10 million now. And I hope it will be worth 20 or 30 or 40 million in years to come. But they just decided they're going to buy 5 million. They're both in their 30s, young guys, and they bought a policy through 65. And they're just going to ride that pony. And they feel like, look, if I pass away, my spouse or my kids get $5 million, they'll be happy, I'll be happy. So that's one way to do it. But again, downside, doesn't account for growth or decrease in value, although you could agree on your key man to adjust that every few years. Am I good now?
You're still, yep, these are still you, but.
Okay, sorry, thanks. So let me talk now about some preventable errors. And I could recast this. If you have a buy-sell agreement already, I would say things you should look at right now if it's in your agreement, right? You know, I don't love Zoom. I use LegalZoom or something. It amazes me that people put so much time and money into their business, but they decide to grab their documents just off the internet, or a buddy had them, or LegalZoom, or whatever it might be. You really want to personalize it, and don't call it boilerplate, because the boilerplate literally is how you value your company, what the triggers are. It's a terrible idea. So if you grab something off the shelf, I'd encourage you to look it over, because it probably isn't personalized to you. The second one is this review. RJ gave you a great example of a review. I, believe it or not, had a dispute in San Diego between 2 70-plus-year-olds who entered into their buy-sell agreement in their 80s, and never touched it. Litigation ensued. It's just not a good idea. You've got to review it and update it. Failure to obtain spouse signatures and joinders. All the buy-sell agreements, assuming you've got competent counsel or you've got a competent form, will have a consent to join, and it will require spouses and community property states to sign it. What's so ironic is that a lot of time they don't go do it. I don't know why. Or they were single when they started, and then they got married. Or they moved in with somebody in California. If you decide to be a significant other after a number of years, guess what? They're a spouse anyway. So making sure that you have all spouse signatures and you have it all in one nice little stack of documents is important. Because otherwise, if you get into a divorce, the spouse can go crazy nuts on you. And then failure to have new shareholders join. I can't tell you how many times I've had, and I find this more in tech and younger companies than older companies, that they give 1%, you know, or they have a contract and they go, oh, I'll give you 1,000 shares. They never, ever, ever paper it. And then that person, you know, decides to go or whatever. And now we've got this whole problem where we say, well, you're bound by it. You have to sell. And it's like, well, show me my signature. I don't have to sell. And you're like, well, you knew it. Oh, that's going to be helpful. So make sure you get everybody to sign off on it. And then failure to attach the promissory note. Now, you don't have to do this, but guess what? Litigation can ensue over terms. Because what happens if the business has a mandatory? Let's say you've elected, as RJ told you, you can either do mandatory or optional, right? So let's say it's a mandatory buy if a person dies, okay? And you do not have the money. Guess what? That doesn't, the deceased family's estate, they don't care. You have no defense. But if you put in your buy-sell agreement, we have terms. It's going to be over 5 years, 20%, It's going to be 6% interest. It's not going to be secured. There'll be no prepayment penalty. And here is the note that we agree, and we are going to attach it. That will eliminate all the problems of future funding. It will the disputes about what the terms should be or not. But if you do not have the note, reasonable people can differ. Well, what interest rate should it be? How long should it be? What should the terms be? Should it be interest only or principal? What should be amortized over? And oh my goodness, you can litigate over that. So have the note. This one, I guess, has to be me because this is what I litigate. And I would say of those 500 plus divorces, I wish I would have really counted because I think I'm actually over 1,000, but I don't want to exaggerate. But this is the number one. It's on there. No buy-sell agreement at all. I just don't know what to say. They just didn't talk about it, and then they're parting ways. The second one is the value of the company is unclear or unknown. Obviously, that's just a huge issue and an area for disagreement. And usually the number one thing is this one, which is minority or marketability discounts. You know, if the person going out is the minority, they're going to say they shouldn't be there. And the majority is going to say, yes, there is. And that dispute is so real and impossible to resolve, you know, naturally, because the case law doesn't help you on that. And especially, like I said, traditionally fair market value means discounts apply and fair value doesn't. But heck, judges don't care. Your criminal court judge who decides your business divorce is not going to understand the nuance between fair market value and fair value. And then the missing of triggering events. And if I could put one little caveat that on that one, independent contractors or partnership distributions, that we use the words employment trigger, but if you are 1099ing yourself, if you're taking distributions, what if all you do is sit on the board? Those are also really important things. And I just used one as a category, but I am in litigation right now over a 3-member company where none of them were employees, but all of them were doing work for the company. All of them had a consulting agreement through their entities. And guess what? They didn't have a buy-sell agreement. And so one of the entities has decided to pull out. Is that a trigger event or is it not? And then company lacking or shareholders lacking funds. Guess what? If there isn't financing, there's nothing you can do. You can sue the company or the other shareholders, even if you have a mandatory purchase event. Doesn't matter. If the money isn't there, there isn't. And so RJ is going to spend some time, and I think I might even jump in a little bit about some other ways where you can make sure that you have that particular funding. And then no written agreement on the distributions from the business. Yeah, that one could be a whole separate subject because, you know, most people will distribute based on their percentage of interest, but disagreements can happen on employment and what they did or didn't do and how involved they were and how they weren't involved. And I have one right now. It's an 85-15. The 15 is the president CEO. The 85 is a figurehead. And the 85 is taking a huge salary and the 15 wants to reduce the 85's compensation down. There's no employment agreements. I don't know how this is going to play out, but it'll be interesting. So you might see another piece of litigation soon because of no written agreement.
So for those of you out there listening to these checklists of things and you're going, oh my gosh, I didn't realize it was so complicated, or I wonder what our agreement says. We want you to take action. Whether obviously we'd love to sit down with you and in that 30-minute complimentary conversation just to talk about your situation, but regardless, where can you go from today? Well, I'm going to suggest something, and that's where you go and stress test your buy-sell agreement, which of course assumes that you have one, but why not go through a dry run? Why not go through and ask and just pretend that you or your other partner died yesterday? Now, what happens? What would you do? Who do you call first? Where's your agreement? Dust off, blow off the dust. What's it say? What if, and then again, what if it's not a death? What if it's a disability? And just go down the list of some of the things that Troy's been sharing. So why not do a dry run just to see what happens? Who would do the valuation work from the triggering events? At least what your documents say. What are the expectations that you or other shareholders might have in terms of receiving value from the buyout? At what value? What number? Ask your spouse if you're married. How would you feel about getting this amount if, God forbid, I was killed or permanently disabled tomorrow? Have real life conversations. So this gives you a chance to clear up misunderstandings. Ask your partner, how do you read this? Ask your attorney, hey, what's this really say and mean? And before the end of the year, and literally, if it's not by the end of the year, if you're a calendar year and you've got lots of things to finish up like we do as well, make it on your agenda for January, that you're going to sit down and you're going to go through this with your business partners, your legal counsel. A great dress rehearsal avoids you having to go see Troy. As delightful a person as he is, go play tennis with him. Do not have to go see him in the courtroom, okay? So let's see, that was, I'm just going to touch on a couple of things here. Again, you really need to have the business valued. It's absolutely critical. Since many of you will be asking for copies of the slides, I'm not going to spend a whole lot of time on this, but you just need to make sure that they are regarded as an industry expert, and look at their experience. What have they done with other companies? What are their credentials? Again, I'm not going to drill into this, but you need to have somebody. This is not somebody who's just out fresh on the street and just hung their shingle up. Let that go for somebody else. You want to get the person that knows what the heck is supposed to be in these agreements in the valuation of the company. Okay, so these are some things that you do want to say in the buy-sell agreement. This is from my friend Cheryl. Make sure that you have an independent business valuation expert with these particular credentials that spends the majority of their time valuing businesses. Put that into the language of the buy-sell agreement. Don't leave that for chance. And ideally, specify a specific valuation, either firm or an individual, but make sure that if you do that, you need to make sure that that gets updated regularly. Okay, obviously, is the point of it, you need to have, it's been said that if you have enough money, that will solve 90% of any situation. It's the 90% solution, as another mentor taught me years and years ago. But too often it's missing in the agreement. Either they might put life insurance in there, but very seldom is there disability insurance that's included for the buy-sell agreement, in part because it's expensive, because it also has a much higher probability of occurrence. But the other part of it is if you have a company that's 2, 3, 4 years or so, it may be very difficult, if impossible, to get the disability insurance. But just because you may not be able to buy it initially doesn't mean you shouldn't try and then add it later on. You know what? I think, did I jump into your space here, Troy? I'm sorry, I did. So I'm going to back out from here. Sorry about that.
No problem at all. So, one of the reasons, just to kind of echo what RJ said in terms of the funding, I have found that insurance is a great way to handle it. E-Man, I think it's nice to know that there is a pocket where the money comes from and you don't have to worry about it. So I'm a huge proponent of E-Man, and if you can afford it, that's what I like to see. We already talked about promissory notes, so we can jump down on that one. Obviously, cash is king, and who wouldn't love that? And hopefully you can find financing. And if you need help, RJ has connections. I have connections. There are people out there that will buy companies. They will pay money to purchase interest in companies. I work with lots of different angel investors, private equity people, etc. So there's lots of resources out there to find the cash component if you need it, if you can't get it through your own lending sources. An ESOP has become, depending on the industry, can be a good way to take care of the acquisition, especially if the company doesn't have the financing. Let the next gen buy out the partner or partners that are going. And obviously, if worst comes to worst, you can sell the company, or not worst comes to worst. Maybe you decide it's time to call it a day. and M&As are a great deal, and I've done hundreds of them, and I love them, and I think it's fun when you sell and you get that payday at the end. But of course, it does cut off your revenue and your opportunity, and so it's a decision that should, in my opinion, not be taken lightly, and for sure it shouldn't be a decision that you make out of necessity. It should be something to plan.
Yeah. And just as a quick point, because sometimes I get asked, I make the assumption that people know what an ESOP is. That's an employee stock ownership plan. In some companies, very rarely, and frankly, in my career, have I ever seen a situation where an ESOP makes sense. We'll talk about it as a succession planning device, but when we start talking about what the cost is to do the annual valuation and all the other mechanics, that usually stops the conversation. It does fit. I've had a couple of clients do ESOPs, but it's pretty rare. But nonetheless, it is something to consider. Okay, I've talked about, we're going to kind of fly along here these last couple of slides so we can leave some time for Q&A. But as I've mentioned, too frequently, disability insurance is missing from the buy-sell agreement, and yet it's 3 to 6 times more likely to occur as compared with someone dying. So with life insurance, it's really easy. Either they're cold and stiff or they're warm and breathing. But with a disability, it runs all over the gamut. So it's best to have an independent life insurance company or insurance company that's making the decision as far as whether something is in fact a disability or not. There can also be disparity in age, health. There could be needs for whether the financing in the life insurance and disability is going to be temporary or whether it'll be permanent. The largest case that I'm aware of that we were able to secure in a very short period of time was up to $50 million, literally in a couple of weeks. It's a specialty product from an outside insurance conglomerate, where if somebody is extremely key to the business and the business would absolutely come apart, we're able to get on very short notice large amounts of life insurance. But of course, the person has to be insurable as well, and there have to be other things. The sun has to be smiling and favorable for that to happen. But it is possible to get insurance quickly, but it's very seldom, frankly. So if you need to have some funding in place, either for loans or key man insurance, buy-sell agreements, you got to give time to be able to put that into place. And then with how do you handle increasing business value? We have a public relations firm that is absolutely on fire. So we just increased their insurance. So now they're each at $6 million between the partners, but we'll put another $2.5 million of key person insurance in place. And as the value of the company grows, we'll repurpose some of that key person insurance into insurance with buy-sell agreement. And I've already talked about how difficult it is to fund disability insurance, particularly of an early company. So Troy, why don't you start bringing us in for a landing?
Yeah, and I think we can just kind of skip this, or not skip it, but just the key here is you got to plan for it, right? A lot of entrepreneurs don't want to talk about it, but you're going to exit someday, whether you die, get disabled, quit, retire. So you got to do something. And that's really kind of the point here. And RJ, why don't you put them all up there, because from a time standpoint.
Okay.
So there are other things here. We don't have the time. We've ran out of it. Sorry. And we talked even fast. So, but we just get so jazzed with this stuff. But I would encourage you to look at this, because buy-sell agreement in and of itself is not the only thing, right? If you really want to get your business planned well, these are the things that you should talk about, all of them. And I want to make sure it's understood too, a buy-sell agreement and a shareholder agreement are essentially one and the same. So don't, I've had some people actually talk about that before. And so, when you see these kinds of things, if you go, well, where's the shareholder agreement in there? It's the same thing. But the tying of your estate planning documents, your trusts, your insurance, disability, etc., as well as succession planning are important. Go ahead, RJ.
Great. I do want to do a shout out on something that I just really started encouraging clients to put in place really in the last 12 months, and this family values trust. Yes, you've got, typically if you're working with a great estate planning attorney and a great business attorney like Troy, you're going to have your wills and your living trust and other things. You may even have a trust that provides assets then for your kids or family and heirs for generations. Not in California, I might point out that we really need to have that trust domiciled in Nevada, South Dakota, or some other places. But a family values trust is actually separate of that. It's not designed to give money in the pocket of heirs. It's designed to help continue the values of the family, of you and your spouse, that you've been hopefully pouring into your family and your heirs. But too often over generations, those family values that help create the wealth are lost. So a family values trust is a standalone trust, and that money is used simply to help educate your heirs and help imbue within them the value system. If you think about an apple tree, it's the roots and the tree trunk itself, but it's especially the roots that help to create the wealth in the first place. It's not just the fruit, and the fruit is what's typically being directed through the wills and trusts. Now, something especially separate. And then the other thing is long-term care. Way too few people have long-term care insurance in place, and you absolutely need it. I can tell you that's one of the best ways to wreck a great succession plan is if you don't have long-term care insurance in place. Now, again, the purpose of having some insurance in place that's key person is that if you lose that talent, one of the gentlemen that's I think on our call today has an extraordinarily valuable member of his team that if God forbid something happened to that person, it would be devastating financially. Probably wouldn't end the business, but it would make life extremely difficult. So if you have some of those key people, make sure you've got a bonus plan or something that puts in place a velvet handcuff that they will stay for so many years. You might consider what I call synthetic equity plans, which is not actual stock. Please don't give people 1% or 2% of the stock. If you can talk about litigation matters for Troy's firm and things that can explode, that seems to be one of the biggest ones where a business owner gives some key people 1, 2, 3, 5% of the stock. And once you do that, you can't get it back. It's very difficult. So just don't go there. Start with synthetic equity, a stock appreciation rights plan, phantom stock plan, some other things that we can talk about in that complimentary conversation if you want. And then if, God forbid, something happens, going back to that stress test of the buy-sell agreement, clearly address who's going to assume the management roles and in what circumstances will that happen. And will the business be continued? State it clearly in your documents, not just a buy-sell agreement, but also in your living trust document. So, okay. Just to kind of wrap it up here, land the plane, finding a replacement partner or shareholder with the right skill sets can be very challenging, especially as you've grown together over the time. And if you are bringing in somebody as a replacement partner, understand it's going to take time and money to help do that. So just make sure you've got plenty of life and disability insurance for key person replacement, for money to go maybe steal a partner. And again, for insurance for the buy-sell agreement, make sure your lines of credit with your bank are in place before you need it. Best time to have a parachute is before you need a parachute, or you'll never need a parachute again. And then make sure that your bankers, your customers, the people that need to know are being introduced to your succession team. So as we wrap it up, Troy, why don't you take these first points for us here?
Yeah, just we highly encourage you. We will consider ourselves have been a success on this webinar if you implement or review your buy-sell agreement. So that's our #1 goal. We hope you do it. We're happy to help you if you want, but regardless, please do that. And then, work as a team. RJ and I have worked together as a team on some mutual clients, and as you see, we're not the only two that are involved in our clients' lives. I think everybody needs to have a good team, and I think it's good because there's inner workings that are involved here. And as I mentioned, buy-sell is critical, but it's not the only thing. And so those are some people that, at least for my clients, if they're doing what I call the A team or the A business planning, you'll have somebody in each one of those categories. You may budget-wise or otherwise not be able to afford everybody, but it's great to get different viewpoints. And so I would just encourage you to, be a sponge and soak up as much good information as you can from other people, because there's a lot to be learned from different disciplines that will assist you in trying to plan how you want to handle your buy-sell.
Consider this as an investment. You're making an investment, many of you, into hundreds, and in some cases, millions of dollars of investments into plant and equipment. Well, why shouldn't you invest $10, $15, $20, $50,000 potentially? I'm not saying it's going to cost that, but I mean, again, if you want a professional team, depending on the size of your company, why not invest that money into making sure that you're getting the best counsel you possibly can? And again, not sure why that's not coming up. There is a next slide. There we go. Again, please stress test your agreement if you do have one. Get a valuation, or make sure that your valuation, unless it's been in the last couple of years, get a valuation done. Talk with an insurance specialist, someone who's knowledgeable about what the various products are. There's also, I would advise, an independent advisor, not just simply working for one insurance company. And then last, there are a few of us who have now been trained in this area of exit planning. I happen to be also a CEPA, Certified Exit Planning Advisor. But make sure you're talking with specialists that have experience in working with succession plans and exit plans over many years. So again, this is not something you want to try at home. You don't want to. There's the largest battleship in the world called the Voya sank in 1654, I believe, in Sweden. And it sank. It was the largest battleship of its kind. It sank literally in 20 minutes on its maiden voyage. The reason, there were number of reasons, but one of the reasons was the shipbuilder that they hired had never built a multi-deck battleship with guns, and he simply built it too heavy, and the ship went out, was top heavy on one side, not top heavy, it was way too heavy on one side of the ship. A couple of gusts of wind came, blew it to the port, and all of a sudden the ship sank and 33 sailors died in the process. So make sure you're working with somebody who knows how to build a right battleship. And with that, we're going to wrap this up. We are being recorded. We're a few minutes over time, but we do have some questions that we do want to address. So if you need to leave us, thanks for being with us. It's been great. We are recording this. You will get access to the recording, but if you want to stick around, we did get some questions. And so Troy, one person writes, I'm an owner of a company with several family members. We don't have a buy-sell agreement. I'm apprehensive to suggest one because I feel like it will make my families think I don't trust them. I've heard that before. Do you have any advice on how to introduce the idea of a buy-sell agreement such that it makes your other owners and your family members want to get one rather than it's, again, something that you don't trust them? How would you approach that?
Yeah, I hear that. I think a fair amount. People think it's almost like a prenuptial for a divorce. Like, no, I'm insulting your integrity. I'm not trusting you. But the reality is the beauty of a buy-sell agreement. There's two things that I think you can sell a buy-sell to somebody on. The first one is it's as much a protection to them as it is to you, right? I mean, what if you're the person that dies? What if you're the person that becomes disabled? What if you're the person that quits? Would they not want to have a well-set plan? I would think they would, you know. And then the second thing is that if most companies are hoping to grow, I don't know of any company that really is hoping to get less or retract. And so if you are going to grow, that usually means you're going to bring on another shareholder, another member, VC firm, whatever it might be. You need to put in place a plan so that it allows for future expansion. And that's what a buy-sell agreement does. It's not just for the 2 or the 3 or 4 owners right now. It's also for numbers 5, 6, 7, and 8. And so you can introduce it by saying, hey, look, you know, I know we're thinking about bringing on John again, or, you know, I think we're thinking of bringing this VC firm on. I think we really should get a buy-sell agreement in place before we do that, so that when they come in, they know what our plans are. And so it's a collaborative kind of thing. So that's what I do.
Great. That makes a lot of sense. Those are some great points, Troy. We've got a question that's coming from Angela. Would you recommend that a business owner have a separate buy-sell agreement, or would it be acceptable? Does it get the same job done if they include in the operating agreement of the business? Again, this is a 50-50, either partnership or LLC appears, or a business. Is it acceptable to just simply address some of the buyout issues in the operating agreement itself?
Yeah, I would say in an LLC agreement, I would say I see more often than not them putting the buy-sell portions of it right into the operating agreement. I mean, one of the beauties of an operating agreement is there's only one place to go instead of a corporation with articles of incorporation, bylaws, shareholder / buy-sell agreement. So some people like the whole purpose of an LLC is to make it simple, and some people like to only have one place that they look. So legally, it doesn't matter whether it's called a buy-sell agreement or it's part of your operating agreement, but if you put it in the operating agreement, make sure it's comprehensive. Don't just say, oh, and we buy out, right? I mean, it needs to have the same bells and whistles as a buy-sell agreement, but the title is not what's important, it's the content.
Great. So a couple other questions I think you've already addressed in terms of, is there a difference between a shareholder agreement and a buy-sell agreement? And I think you've addressed the fact that, nope, those are basically.
Yeah, they're synonymous. It's like lawyer, attorney.
And also, what happens if it's a husband and wife that are owners of the company? Should they have a buy-sell agreement? And again, short answer is yes, with a large exclamation point, right?
Exactly. I just did, unfortunately, a real estate agent group that the name of their company is their last name. And they got divorced. And the question was, who gets to have the name and all kinds of things. And they didn't have a buy-sell agreement. And they were 50-50 owners, of course, because they were husband and wife. Just a complete royal disaster, and it's really unfortunate. And if they would have done this in advance, they could have addressed all those issues.
Again, folks, if you do have more questions, go into the chat box there, and we will be able to respond to that. So we have one more question before we wrap up, unless there's anything else before we finish from others. Question is, we have an investor group that's looking to invest into our company. They want us to get rid of our buy-sell agreement in exchange for their investment. What do you think? Is that a smart idea? Is that a wise idea? Or is that a dangerous idea?
Well, if they're giving you 30 million bucks, take it. But I'm assuming the person asked the question because they are uncertain. And here's my thoughts on it. I would say that you should always, the first position should be keep your buy-sell, because any investor that's coming in, you want to be in control of the process. If you show them that you are so desperate that you'll take their money, they're going to know that they've got a superior bargaining position. And one way to do that is to throw out your buy-sell agreement that you've had for years. So I would say always, no, it stays in place. Now, in the end, if they absolutely insist on it, then, you may make the decision. But I just did one with an institutional investment company based in the Middle East who said they would absolutely never, ever, ever do it, who agreed to do it. Now, we had to amend the buy-sell agreement to give them all kinds of superior rights. We had to give them a distribution right throughout the Middle East for the product. We had to do all kinds of other goofy nut things, but we still kept it in place. Because keep in mind, if you dump your buy-sell agreement to bring in the VC, what happens if still the 10% owner decides to leave? It's not like your relationship with all your other partners / members, shareholders goes away. You just got one new one. So do you really want to scrap your relationship just to go get some money? So I would generally say no.
Great counsel there. Thank you, Troy. So that's it for today. Again, welcome to, I'm so glad.
There's one more chat, RJ.
Oh, okay.
From Kevin.
From Kevin. All right. Good.
What's the median price of a buy sell, and how long does it take to create?
Okay. Oh, there it is. And well, actually, I'm not.
You're not seeing it?
I'm not seeing it. So.
Well, I read it.
Go ahead and address that. Yep.
What is the median
price?
Kevin,
I'm not seeing it.
That's an interesting thing, Kevin. What's the median price of a buy-sell, and how long does it take to create?
I think that in terms of what's it cost, what would it cost for an agreement?
I get you. Sorry, you're looking for cost. I was like, median price of buying an agreement. The answer to your question is it definitely varies. I usually tell clients $2 to $5 grand, and it's going to be in that range 85 to 90% of the time. The reason that it would go lower is if it's like a husband-wife and they want just a really bare bones kind of thing, and they're not going to make any changes at all. I just send them the document. They go, oh, I love that. And it's going to go a lot higher if it's 3, 4, 5, 6, 7 members, and each has their own lawyer, and you go through 8 drafts, and there's 10 meetings, and then it could be 20 or 30 or 40 or 50 grand. But generally speaking, they run $2 to $5 grand for my firm.
Great. Good. Well, thank you for that. And I'm not quite sure why it's not showing up on my chat box, but I'm glad that you saw it. So with that, let's wrap it up for today. And Again, thanks everyone for joining us. You will get a request for your feedback. Let us know, was this helpful? What could we do differently? How can we do it better? That's how Troy and I can create more and better presentations to give you the content that you're looking for. Several of you have asked if you'll be able to get a recording. Yes, we'll be making that link available here in the next, certainly by the end of the day or by tomorrow at the latest. I want to thank Olha Martinez, who's our wonderful staff member at Wealth Legacy Group, who is involved with behind the scenes stuff. Thank you, Olha. And then as well, if you would like a copy of the slides, when you respond back to us, just ask us for that. We'll get you that. And then last would be, again, if you want to have that 30-minute complimentary conversation to just discuss your buy-sell agreement or really actually anything on your succession plan or otherwise, let us know. That's complimentary on our part, and it helps us give back to you. Again, I want to thank my wonderful co-presenter, Troy Romero of Romero Park. Thanks, my friend. Great being with you. I see we can, and thank you. I'm getting a lot of lovely comments from folks. Thank you very much. Well, it was our pleasure to be with you. God bless everyone. We've got an important election coming up, but at the end of the day, we are Americans. We will find our way through this despite what's happening. Our founding fathers were pretty darn smart in terms of how they built things up. And I still think that there's the hand of Almighty God over this country, despite the stuff we see maybe to the contrary sometimes. But it's the country that I would choose to live in, and I've been to many of them. This is our country, America. Lots of good things to love about it. So God bless, and again, thanks for being with us today. Bye for now.
Thank you.